What starts as a simple arraignment quickly turns into a tense courtroom standoff. A man facing a charge for driving on a suspended license appears before the judge, but instead of answering basic questions, he begins interrupting with so-called sovereign citizen arguments. He claims he's a beneficiary sovereign, questions the court's authority, and insists he doesn't understand the charges. The judge stays calm and explains that this is just an arraignment, not a trial. He outlines the penalties and tries to move the hearing forward. But the interruptions keep coming. Legal jargon, jurisdiction challenges, and repeated objections only test the judge's patience further. Eventually, the judge enters a not guilty plea on the defendant's behalf and sets the case for trial. He gives a clear warning: cooperate and follow the process, or risk facing a bond requirement and even a bench warrant for failing to appear. What should have taken minutes becomes a bigger legal headache, all because one man refused to play by the rules.
Your Honor.
All right. I'm going to read this to you so you understand what you're charged with. This says that on January 7th of this year, on 2nd Street there in the city of Fenville, that you were driving while license suspended. That is a misdemeanor. It's punishable by up to 93 days in jail and or $500 fines.
I do not understand my charges or
okay, I'm going to mark you down as not guilty, and we'll set you for a jury trial. You can continue to...
Your Honor, Your Honor, you practice in front of bench. You practice in front of bench. That's my job or my attorney job. I'm sui juris. I'm pro prior person.
Okay, Mr. White, I don't know where you read the stuff that you're saying, but it's legal nonsense. It means nothing in a court of law. So if you're not willing to state that you even understand or recognize the authority of the court, my options are I can make you come in for arraignment and not give you a PR bond, and then you'll have to post bond to not sit in jail. You want to do it that way instead? Right now, if I get through arraignment with you, I'll give you a PR bond. Mr. White?
Listen. I'm asking you a question.
What's the question, sir?
I'm not arguing with you, Your Honor. I just want you to hear me. I just want you to hear me.
Okay, but I don't want to listen for 20 minutes. Go ahead and ask your one question, and we'll start there and see if it's a real question.
Am I on the record?
Yes.
It's not going to take 20 minutes, Your Honor. I give you my word.
Well, you said you have a question, sir. What's the question you want to ask?
Is this criminal or is it civil?
This is criminal, sir. It's punishable by up to 93 days in jail and or $500 fines and costs.
Hey, if it's criminal, because at this point, the prosecutor, there's no sworn testimony, there's no sworn.
It's because this is just arraignment, sir. What you're talking about is trial. That would be several steps down the road. Arraignment is just for you to make sure that you understand what you're accused of, what the penalty is, and for you to enter a plea. You're accused of driving while license suspended. I read to you what the possible penalties are, and I asked you if you wish to plead guilty or not guilty at this time.
No, Your Honor, I'm a beneficiary and I'm a sovereign. I'm here under fraud, menace,
okay, sir. Those sentences don't mean anything. They have no legal meaning whatsoever.
It's guaranteed by
so
my constitutional
I've indicated that since you can't understand arraignment, I've entered a plea of not guilty on your behalf. I've set you for a jury trial. You can represent yourself free of charge, or you could hire an attorney. And now you must make a choice, sir, for bond. If we get personal recognizance bond, that means you don't have to post any money. We're essentially trusting you that you'll keep coming back for your court dates. It is no driving without a valid driver's license. If you cannot get that far, in other words, if you really don't understand what's happening here, then I'm not going to allow you to be arraigned by Zoom. I'm going to set you for arraignment in person. And you will come to this courthouse. You will not get a PR bond. You will get a $300 cash or surety bond, meaning that you will need to post $300 in cash, or you will sit in jail from that day until your trial date. So I'll give you a choice. Do you want to be arraigned over Zoom like we're doing today, or would you like to come in and be arraigned in person?
Well, I object to all this, Your Honor, because at this point, I don't even understand the charges. I do not understand the charges. I'm not trying to.
That's fine. No, sir, you're allowed to, sir, you're allowed to object, and I understand your sentence that you don't understand the charges. And so I will attempt to work with you for that for a second. I'm going to read the charges to you, okay? This says that it takes place on January 7th of this year. You understand that, right? The date that I just read.
I'm saying I do not. At this point, Your Honor, it's I was saying this. It was a jurisdiction matter. It's a jurisdiction matter. That's what I'm saying. It's a subject matter, jurisdiction.
Here's the problem with you arguing jurisdiction. I am a lawyer, so I understand what jurisdiction means. You're driving around on 2nd Street in the city of Fenville, meaning in Allegan County, and that you're doing so when your driving privileges with Secretary of State have been suspended or revoked. Because this is the county. Yes?
Objection. I travel. I don't drive.
Okay.
I have no contact.
Sir, here's what we're doing, Mr. White. You are no longer able to be arraigned by Zoom. What I'm going to do is adjourn this. I'm going to adjourn this, and you will get notice at your address there. You will come in, and we will arraign you in person. I'm telling you that I'm not going to give you a personal recognizance bond, sir.
It has to be. Before we can proceed, before you can proceed, it has to be addressed, Your Honor.
Because we are on the record, I'm going to make this infinitely clear. You're going to get notice to appear in front of me. You have 2 choices. If you do not appear, I'm going to put out a bench warrant for your arrest. If you do appear, we will have this conversation again about arraigning you to see if you understand the charges, but you are not getting a PR bond. You will need to bring with you $300 cash or surety, or you will be in jail. Do you understand those 2 options, A and B?
That's a violation of my constitutional rights, Your Honor.
Well, no, it isn't, sir. So we're all set for today. We're done talking. We cannot make any progress. You will be asked to come in person for arraignment. You can either choose to come in for arraignment or you can choose to not be here. If you choose to not be here, a warrant will be entered for your arrest. And if you do choose to be here, make sure you bring that $300 because you're not getting a personal recognizance bond. But we are done with this hearing. I'm going to go ahead and release you. Thank you.
When's my date for court?
This courtroom hearing begins like so many others. A simple arraignment, a straightforward charge, and a judge ready to move the docket along. The allegation is driving with a suspended license. Not the most serious charge in the world, but still a criminal matter that requires procedure, clarity, and cooperation. Normally, these hearings are quick. The judge reads the charge, explains the possible penalties, asks for a plea, and sets conditions for release. 5, maybe 10 minutes at most. But almost immediately, it becomes clear that this hearing is going to be anything but routine. The judge begins calmly, explaining the purpose of the arraignment. His tone is firm but measured. He outlines the charge and attempts to confirm the defendant's identity. Before he can even finish, the interruptions begin. The defendant starts speaking over the court, insisting that he does not consent to the proceedings. He refers to himself not as a defendant, but as a beneficiary sovereign. He questions the legitimacy of the court. The judge pauses. He tries again. He explains that this is not a trial. No evidence is being presented today. No witnesses are being called. This is simply the formal reading of charges and the entry of a plea. The process exists to protect the defendant's rights, not to violate them. But instead of acknowledging that explanation, the defendant doubles down. He says he does not understand the charges. The judge reads them again, slowly and clearly, driving while license suspended. He explains the maximum penalties, possible fines, possible jail time, the right to an attorney, the right to a jury trial, the response, more legal-sounding phrases that don't actually address the charge. The defendant starts referencing obscure Latin terms. He claims to be sui juris. He mentions appearing propria persona. He suggests that because he identifies in a certain way, the court lacks jurisdiction over him. The judge listens, then responds directly. He explains that those terms do not strip the court of authority. They do not invalidate the charge. They do not stop the process. You can feel the tension building. The judge is clearly experienced. He has likely heard variations of these arguments before. His voice remains steady, but there's a firmness now. He warns the defendant that continued interruption will not help his case. In fact, it may lead to consequences. Still, the interruptions continue. At one point, the disruptions become so persistent that the defendant is temporarily placed into a virtual waiting room during the Zoom session. It's a moment that highlights just how unmanageable the situation has become. Courtrooms, virtual or physical, operate on order. Without order, nothing moves forward. When the defendant is brought back into the hearing, the judge makes another attempt. He carefully explains what jurisdiction means. Jurisdiction is not a magic word that erases charges. It refers to the court's legal authority to hear cases of this type within this geographic area. The charge occurred within the state. The court is a state court. That's jurisdiction. But the defendant insists that he does not recognize the authority. The judge clarifies again, personal beliefs do not override statutory law. Refusing to acknowledge the court does not make it disappear. The system does not depend on verbal consent to function. Time passes. What should have been a brief procedural hearing is now dragging on. Other cases are waiting. The judge's patience is being tested, but he continues to explain the basics. He tells the defendant that if he refuses to enter a plea, the court will enter one on his behalf. This is standard procedure. It ensures that the defendant's rights are preserved and that the case can move forward to the next stage. Instead of answering clearly, guilty or not guilty, the defendant continues to argue philosophy instead of law. He challenges definitions. He asks circular questions. He claims confusion while simultaneously asserting that the court has no power. Finally, the judge makes a decision. Since the defendant refuses to enter a plea, the court enters a plea of not guilty on his behalf. This protects him. It ensures that he will have the opportunity to contest the charge at trial. A jury trial is scheduled. The judge explains what that means. Evidence will be presented. Witnesses may testify. The prosecution will have to prove the case beyond a reasonable doubt. Then the conversation shifts to bond. The judge offers an option. The defendant can be released on personal recognizance under certain conditions, meaning he promises to appear for future court dates. Alternatively, if he insists on appearing in person without cooperation, a $300 cash or surety bond will be required. Instead of acknowledging the options, the defendant returns to jurisdiction arguments. The judge responds with increasing firmness. He explains that misunderstanding legal terminology does not invalidate the process. He points out that repeatedly interrupting the court is not helping. In fact, it is creating more complications than necessary. At one point, the defendant suggests that he does not stand under the name being called. The judge clarifies that wordplay does not alter legal identity. The court record reflects the legal name associated with the charge. That is what matters. There is a noticeable shift in tone now. The judge is no longer just explaining, he is setting boundaries. He warns that failure to comply with court procedures can result in a bench warrant. That means law enforcement would be authorized to arrest the defendant for failing to appear. The defendant seems unfazed, continuing to speak in fragmented legal phrases that sound authoritative but lack substance in this context. The judge reiterates, this is not a debate forum. It is a court of law. The purpose today is simple: enter a plea, set bond conditions, and schedule the next hearing. Because cooperation never fully materializes, the judge adjourns the Zoom arraignment and orders the defendant to appear in person. A $300 bond is set. The instruction is clear: show up as ordered, or a bench warrant will be issued. The hearing ends not with resolution, but with escalation. What makes this exchange so striking is not the severity of the charge. Driving with a suspended license is a common offense. Many defendants handle similar arraignments quickly and move forward with minimal disruption. What transforms this moment into something dramatic is the refusal to engage with the system as it exists. The defendant attempts to challenge the foundation of the court rather than address the allegation itself. Throughout the hearing, the judge consistently separates belief from law. Personal ideology does not override statutes. Internet theories do not dismantle jurisdiction. Latin phrases do not nullify criminal charges. The courtroom operates on established legal frameworks, not semantic loopholes. The judge's handling of the situation reflects a balance between patience and authority. He explains repeatedly. He warns before acting. He gives options before imposing consequences. But when cooperation fails, he exercises the authority of the bench. For viewer, the exchange becomes a lesson in how courtroom procedure actually works. An arraignment is not about debating sovereignty. It is about ensuring the accused understands the charge and has the opportunity to respond. When that opportunity is rejected, the court moves forward anyway. In the end, the most powerful takeaway is how quickly a minor charge can become more complicated. What could have been resolved in minutes stretched into a prolonged confrontation. Not because the system malfunctioned, but because participation in that system was resisted at every turn. The judge remains composed to the very end, making it clear that the rule of law does not depend on agreement. It depends on authority granted by statute and constitution. And in that courtroom, that authority remains firmly intact.